recent Court of Appeals decision addressed one issue important to all Michigan motorists. When is someone disqualified from no-fault auto benefits? Because you can be. Here to review that concept and recent decision is attorney Tom Sinas of the Sinas law firm. Tom, talk about the concept of being disqualified from those no-fault benefits.
You're right, Derek. You and I have talked a lot over the years about when people can receive no-fault benefits, but there are certain circumstances where someone who otherwise would be entitled to receive no-fault benefits is disqualified. And what does that mean? It means we have a provision of our law that says under certain circumstances, certain people cannot receive no-fault benefits because certain things have happened. So what are the most common? Well, the most common way that someone can become disqualified is what we sometimes call the uninsured owner. That means if you're the owner of a car and the car is involved in a crash and you did not insure the vehicle, then you, even if you were injured, you would be disqualified from no-fault benefits because you didn't have the requisite insurance on the car. But another less common element of disqualification, but one that the Court of Appeals dealt with in the case you mentioned, is one that is sometimes called the unlawful taking. What does that mean? It means that if someone is willingly using a motor vehicle that was taken unlawfully, and the person knew or should have known that the vehicle was taken unlawfully, then that person, if they're injured, is disqualified from no-fault benefits and, of course, cannot receive those no-fault benefits. There are a couple of others, but those two are perhaps the most common, and the second one being the one the subject of this recent Court of Appeals case.
Yeah. So what does the recent Court of Appeals decision mean for Michigan drivers?
Well, it's unusual and a bit surprising. It involved a situation where there was a rental car, and the person who rented the car let someone else drive the car. And that someone else was not permitted to drive the car under the rental agreement because the someone else didn't have a license, meaning the rental agreement said only licensed drivers can drive this car. And then the unlicensed driver drove the rental car, got into a crash, and got hurt. And the Court of Appeals held, in short form, the Court of Appeals held that that person who didn't have a license, who was driving the rental car, committed that unlawful taking of the rental car and therefore could not receive no-fault benefits. And so what I think the takeaway here is, of course, generally people should not be driving without a license. But what we're seeing in this case is circumstances where driving without a license can also disqualify people from no-fault benefits, depending, of course, on the facts of the case. But in this case, the Court of Appeals held it was enough to disqualify the person.
Interesting enough. Tom, where do people track you down for more information?
They can find us online at www.sinusdramus.com. Give us a call in West Michigan at 616-301-3333 or by email at info@sinusdramus.com.